All right, I just want to welcome everyone. This is the meeting of the Minnesota Sentencing Guidelines Commission for May 11th, 2023. We are holding this as a hybrid meeting under state law. We'll start by approval of the agenda. I will entertain a motion to approve the agenda.
Roll call, perhaps.
Oh, sorry. God, you see, my brain isn't working today. It's beautiful weather outside. We need roll call, so let's do roll call and establish whether we have a quorum.
Roll call, Estrada. Estrada absent. Ibrahim. Ibrahim absent. Knutson.
Here.
Knutson present. Ladd.
Present.
Ladd present. Larkin. Larkin absent. Middlebrook.
Present.
Middlebrook present. Moore. Moore absent. Morath.
Present.
Morath present. Schnell.
Present.
Schnell present. And let me just check the attendees, make sure there's nobody languishing. Oh, there's one. Larkin, we're doing a roll call. Sorry, Larkin.
Present. Thank you, Nate.
Larkin present. So Madam Chair, we have 6 members present, 3 members absent, 1 seat vacant.
Can I be recorded as present as well?
Oh, did I? I didn't get to you, sorry. Chair Mitchell.
Present.
Madam Chair, we have 7 members present, 3 members absent, 1 seat vacant.
Okay, with that, we do have a quorum. Thanks. I would entertain a motion to approve the agenda.
So moved.
Commissioner Ladd moves to approve the agenda and Commissioner Middlebrook seconds. Any discussion on the agenda? All right, hearing none, let's go ahead and vote on that.
All right, so to the motion to approve the agenda, Estrada absent. Ibrahim absent. Knutson.
I vote aye.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore absent. Morath.
Yes.
Morath, yes. Schnell.
Yes.
Schnell, yes. On the motion to approve the agenda, Moore.
Yes.
Moore, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 8 votes in favor, no votes opposed.
And just for everyone's benefit, Justice Moore also just walked into the room, so that adds to the quorum that we have for today. Okay, with that, the motion is approved unanimously. The third item on the agenda is welcome introductions. We don't have any welcomes to make. We do not have official appointments from the governor's office yet, so we're still waiting on those. We were hoping that we would all know those final answers by this month, but we don't. So we'll look for those next month. The next item on the agenda is approval of draft meeting minutes from April 13th. You should have all received these a week ago, and I would entertain a motion to approve the minutes.
So moved.
Commissioner Knutson moves and Commissioner Middlebrook seconds. Any discussion on minutes? All right, seeing none, we'll go ahead and vote on those.
To the Knutson motion to approve the April 13th, 2023 meeting minutes, Estrada absent. Ibrahim absent. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Schnell.
Abstain.
Schnell abstains. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, no votes opposed.
With that, the motion is approved unanimously and the minutes are approved. The 6th item on our agenda is ranking newly created or amended crimes, getting down to the business of the commission following the legislative session. So we do have a few things to sort of exercise our muscles with today. I'll let Director Wrights take us through it.
Thank you, Madam Chair. Yes, as you said, this was sort of thought to be a training exercise for new commission members. We don't have any new commission members, but I will say that based on the conference committee, which we'll be talking about shortly, which just wrapped up last night, there's going to be a lot of work to do in June. So I think any work that we can get off our plates this month would be good. Having said that, though, if there's anything that we're coming across that you just feel like you can't make a decision right now, you want to push it off to June, you do have that flexibility with these particular items. You won't have that flexibility next month because of the meeting rules and basically the August 1st deadline to get everything in place. You really have to make a decision next month on everything that will be presented to you. And we will need a quorum for sure for next month. But for this month, there's a little bit more flexibility. And I'm going to, let's see, just take care of a technical thing here. All right. So I'm going to share my screen here. This is the document 5A. It's called Ranking Newly Created or Amended Crimes, Part 1, meaning Part 2 will be June. June will be a bigger document, essentially. We really have two things to work on today, and these are two laws that have already been passed and signed into law by the governor, having to do with two new or largely restructured offenses. The Commission's ranking decisions are based primarily on the level of harm caused by the offense and the culpability of the person who commits the crime. Those two things together make up the severity, and that's the decision that you're making in ranking offenses is what is the severity of the offense, what severity level should be assigned. Other considerations include the statutory maximum, how similar crimes are already ranked on the sentencing grids, and past sentencing practices may also play a part. There are other decisions as well. Should the offense be added to the list of offenses eligible for permissive consecutive sentences? Typically that has to do with crimes against the person. Should the offense be added to this list of severe violent offenses? Should there be an exception to the length of stay, although that question may be going out of business soon? And are there other modifications that ought to be made to the sentencing guidelines? So we're going to jump right into catalytic converter crime. This is a new crime that didn't exist before. Going to take effect August 1st. And before I get into the three subdivisions, let me start by talking about the penalty. So the penalties here are in these 5 bullets. There's 5 different levels of this offense. There's and it really kind of mirrors theft offenses. There are also 5 different statutory maximums that apply to theft as well. And it depends on the value of what is stolen. It goes from misdemeanor to gross misdemeanor to 3 different levels of felony, primarily depending on value, although there are some other special factors that can also influence the statutory maximum. So here, depending on how many catalytic converters are illegally purchased, possessed, or acquired, that's going to be the determining factor, not the value, although obviously there's a correspondence between the number of catalytic converters and the value of the crime. But it does make things a little bit simpler, I would say, rather than having to prove market value of a used catalytic converter, to just count the catalytic converters. As far as why this crime was created, I did hear some of the testimony in committees about this, and essentially law enforcement. If people aren't caught in the act of actually stealing a catalytic converter, it can be hard to prove that somebody with a used detached catalytic converter actually stole it. And what this bill does, and going back to the description of the bill, subdivisions 11, 12, and 13, they essentially make it contraband to have a used detached catalytic converter unless certain requirements are met. So one of the primary ways of making it not contraband is to mark the catalytic converter with some kind of permanent marker or etching that links the catalytic converter to the vehicle, presumably by the VIN of the vehicle. And so every catalytic converter has to be marked in this way or it's contraband, assuming it's used and detached. And that's pretty much all we're talking about here, are used detached. This wouldn't apply to new catalytic converters or catalytic converters that are attached to a vehicle. So I heard stories about, law enforcement would pull somebody over on the highway, they'd have their station wagon full of used catalytic converters and they'd have some story about it. And there wasn't really, necessarily probable cause at that point to make an arrest, so they'd have to let the person go. So this would really solve that problem. So there are these requirements. There's possession. There's also purchase by a non-dealer or purchased by a dealer. And there's a number of requirements for scrap metal dealers that have to comply with catalytic converters. And there's requirements about how they can purchase it. We didn't really see that there'd be a lot of fiscal impact to this crime for a couple of reasons. One is there aren't a lot of scrap metal dealer cases right now. And secondly, we're assuming that people are, for the most part, going to comply with the law, that this law will actually have some effect in reducing the number of catalytic converters that are illegally possessed or stolen. So here are the sentencing guidelines considerations. So we've got these familiar statutory maximums. That, as I said, these are the same statutory maximums. 5, 10, and 20 are the same statutory maximums that we see on theft offenses. So we analyze this kind of 3 different ways in terms of looking at or 3 or 4 different ways in terms of looking at how you might rank it. The first is to look at receipt of stolen property by precious metal and scrap dealers. So that really has 2 thresholds, $500 to $1,000, and then more than $1,000. That's ranked at 2 or 3. And then if there's a second or subsequent violation, it's ranked at 4. So that's the current ranking for receipt of stolen property by scrap metal dealers. And then the second way to look at it is just what is receipt of stolen property, period, rank it, because you don't have to be a scrap metal dealer to do this. Again, you see the 2 and the 3 for $5,000 or less or over $5,000. Those are ranked at 2 and 3. And then receiving stolen firearm, the commission's ranked at 4. Otherwise, the commission hasn't made any distinctions on receiving stolen property. Then the third way to look at it is looking at theft crimes, which I think is really helpful. Well, I'm sorry, that 2 and 3 is pretty much how theft crimes are looked at. But this third way of looking at it is just looking at that high tier. So the high tier, which is, again, maybe I didn't say this, but it's 3 to 10 is the lowest level of felony. Then it's 11 to 70 is the middle level of felony. It's over 70 catalytic converters, which is, to my mind, a lot of catalytic converters. So you got 71 or more catalytic converters is the high level of felony, the 20 years in prison and $100,000 fine. So, I mean, that's obviously somebody I would assume is, it's some kind of a theft ring or something like that, to have that many catalytic converters. So let's look at that top tier here, the 20 years in prison, $100,000 fine. The commission's kind of all over the map on this particular statutory maximum penalty when it comes to theft-related crimes. And they're listed here. So it goes 8, 7, 6, 5, and 4. I'm going to start with 6, which is the middle one. That's probably the biggest one. That applies to, that's kind of the general theft of over $35,000. Again, all of these have the same 20-year, $100,000 fine, maximum penalty. So it's not every theft over $35,000 that qualifies for this statutory maximum penalty. For the most part, the legislature said it's got to be a fraud-related theft. Theft by swindle, theft by fraud, which includes, by the way, theft by check, embezzlement, wage theft, and welfare fraud are the big players in this severity level 6 year. And If it's over $35,000, then it qualifies. Now, it's just these types of fraud. So let's say, somebody steals $35,000 worth of merchandise from Best Buy, in say a shoplifting enterprise, that would not be a severity level 6 offense because it's not fraud related. So it wouldn't have this statutory maximum penalty. Check forgery, as opposed to theft by check, is ranked at severity level 5. And theft of a firearm, which has the same statutory maximum penalty, is ranked at severity level 4, which we saw is the same for receiving stolen firearm above. On the high side, above severity level 6, we have 2 crimes which directly involve people. The financial exploitation of a vulnerable adult over $35,000 is severity level 7, and identity theft, 8 or more direct victims or related to child pornography, is severity level 8. So those are higher. So I think this is really an interesting question, is how to rank the 20 years in prison, $100,000 fine. Ultimately, staff's recommendation, which I don't want you to, we have to assume something when we're doing fiscal notes, although they didn't have this particular tier when we were doing our fiscal notes, so we didn't make an assumption on this, but if we had, we probably would have assumed severity level 6. Not because this involves fraud, but severity level 6, 7, and 8 involve like a harm to a person. Our analysis was, it may not involve fraud, but boy, if you've got 71 cars that have been disabled by 71 stolen catalytic converters, that's a lot of human misery out there. It may not be the same as stealing from a vulnerable adult or stealing somebody's identity, but it's still a lot of human misery. So we were suggesting that severity level 6 might be an appropriate ranking for this offense.
Commissioner Knudsen.
I forget, what did you reference when we didn't have that tier when we did what?
Well, so we did a fiscal note. Staff did a fiscal note. For almost all crimes that come through that create a felony, we have to do a fiscal note. And for that, a fiscal note, we have to make assumptions. And one of the things we have to do, which seems presumptuous of us, but one of the things we have to do is assume what you guys are going to do when you have to look at this crime. So we have to assume rankings. So for these lower tiers, which did exist in the fiscal note, we assumed that you'd rank the lowest tier at severity level 2 and the second tier at either severity level 3 or severity level 4. And you're going to see that severity level 3 is what we think is most consistent with theft cases in general in terms of the statutory maximum penalty. So sort of and that's, I would say our bias is, like staff's bias is sort of, this is the normal thing. Like this is what fits the best with the existing sentencing guidelines, which may not be your consideration. But our consideration is probably primarily what's the best fit for the existing sentencing guidelines. And our severity level 2, severity level 3, and severity level 6 are the most consistent in terms of the theft offenses overall. But I think a reasonable commission member could go severity level 3 or 4 for that middle one, and have something I would say higher or lower than severity level 6 for the top one. Lower because it doesn't involve fraud, higher because it's just so much, like I said, human misery that's implied by 71 catalytic converters that have been removed from somebody's vehicle. It's my understanding that removing a catalytic converter disables that vehicle, and it's not necessarily a very good time or place for the vehicle disabled. It might really inconvenience somebody or cause a lot of pain or hardship if they don't have the money to replace or repair the car at that point. So so severity level 6 or perhaps even higher for that. So the last way we looked at this was looking at crimes pertaining to motor vehicles, since this is a part of a motor vehicle. So if you were to steal an entire motor vehicle, not just the catalytic converter for it, that would be ranked at severity level 4. Of course, that's just one car. One catalytic converter is a misdemeanor. motor vehicle use without consent, without the intent to permanently deprive the owner of the car is ranked at severity level 3. And the property value doesn't matter for a car. It's kind of like, as far as the guidelines are concerned, the statute does distinguish based on property value, but the guidelines do not. So whether you permanently steal my old junker out there or a much nicer car, it doesn't matter in terms of how severely the sentencing guidelines rank. So I kind of gave away our recommendation and I think I basically explained what we were thinking there in terms of why we were recommending ultimately ranking these at severity level 6 for the crime of, and we're suggesting that you just call it catalytic converter crime. That term is not used in the statute, but it gets really complicated to try to explain the elements of the statute in any meaningful way. And we kind of thought to model it after controlled substance crime, where you don't have to explain all the details of the crime, you just call it controlled substance crime. So catalytic converter crime over 70 converters, we were recommending ranking at 6. 11 to 70 converters, we were recommending ranking at 3. And 3 to 10 converters, we were recommending ranking at severity level 2. We weren't recommending putting it on the list of offenses eligible for permissive consecutive sentences because it's really not a crime against a person. And there weren't any other sentencing guidelines modifications that we were recommending. So I think I could move on to the other one, Madam Chair, but it might make sense to just stop and the two aren't really related to each other. So.
Yeah, I say we just stop and talk here. Does anyone, any discussion on catalytic converter crime from anyone?
Well,
Commissioner Knudsen.
looking at the statute that you included in our stuff, they call it a catalytic converter. I'm just wondering, what did the statute refer to it? If they call it a catalytic converter crime, what do they call it? But it seems like that's what.
Well, it's 3 different crimes depending on who's committing it. I mean, they didn't really have a concise way to describe the crime. So it would be, I mean, I guess probably probably maybe let me find the term here. So yeah, the purchase, possession, or acquisition, the unlawful purchase, possession, or acquisition of a catalytic converter. I would say that would be the more standard way to describe the crime. That would be literally consistent with the statute.
But, Madam Chair,
Commissioner Knudsen.
but they don't talk about the penalties by that definition. They talk about the penalties based on how many, and that number of how many applies to whether it's the possession, the purchase by a non-dealer or by a dealer.
Yeah, I think in the penalty provision, as I recall, the text of the statute, it says anyone who purchases, possessions, or acquires catalytic converters, anybody who violates subdivisions 11, 12, or 13 is guilty of the following penalty depending on how many catalytic converters were purchased, possessed, or acquired. So that's why I would say you probably call it purchase, possession, or acquisition of catalytic converters. But again, that reminds me of controlled substance crime, where you could say sale, or you could say possession. And it's simpler, I think, just to call it crime, but it's not a terribly important point. It would just take up more space.
Yeah, no, I think it's clear enough,
Yeah.
the way that they've titled it. Commissioner Ladd?
Thank you. I think one of the things I struggle with is related to over 70. That's a lot. I mean, that could be 70 individuals. I mean, could it be at a car dealership where they go in and they take it from a commercial property? A lot of times this is going to involve some kind of criminal enterprise to, as you said, a ring. And so, you know, we look at identity theft and we have 8 or more victims. And again, that's a person crime-ish. This is a kind of that way. But I just think the volume is what's hard for me to sort of put into, when we're looking at the ranking levels, just the sheer number. It's so much. And so I struggle a little bit with it falling in that 6 range, just given the volume that would be involved and the enterprise that goes into that. And a lot of times this is happening at people's homes. And so, and it's more than just an inconvenience. They do not have a way to get to and from work, take kids to school. And so, again, I think when you have over 70 victims, I think that's not a small number or a minimal number.
Other comments? Commissioner Knudsen?
Well, it's hard to figure this out because with the prosecution, lump them together. So you got 70, but we're going to charge out these 10 and these 10 and these 10 under, oh, no, I don't think they do that. Whatever they have in their possession, that's what they're going to charge. Or that's what the penalty is.
Madam Chair.
Director Wright.
Thank you. And to your point, Commissioner Kutzen, and it's not to refute it at all. That is true. I didn't mention, though, that there is an aggregation provision in the statute. So a prosecutor has an option of aggregating all catalytic converters in all counties that were illegally purchased, possessed, or acquired within a 6-month period.
I think it's a tough one, because I had the same thought you did, Commissioner Ladd, that each catalytic converter represents somebody who, like, much more harm, because that disables the vehicle and all that stuff. And so then I was kind of going back and forth, and, you know, like, I think what's tough about the law is, like, because they're going after the people who have the catalytic converters, it doesn't necessarily mean they were the ones who committed the theft. But when you get to 70, how could you not be part of some sort of an organized theft, operation? So I don't know. Yeah, I can see your point. Harm is one of the considerations in ranking offenses, and what's the degree of harm here created by the offense. Well, what's the will of the commission? Is there more that people want to talk about? Do people want to try to decide on something today or not? Commissioner Knudsen?
Well, Madam Chair, I think the staff recommendation makes sense. And you've got you're going to have restitution that somebody's going to have to pay for each individual one that could be assessed. And you've got the option to aggravate and seek higher penalties. And it just seems to fit in the scheme of theft the way that the staff has recommended here. So I guess I would make a motion to adopt staff recommendations on placement of those new catalytic converter crimes according to the amounts that are laid out in the materials here.
Okay, so we have a motion to adopt staff recommendations for this offense. Do we have a second?
Second.
Commissioner Moore seconds. Any discussion? All right, hearing none, I guess we'll vote on it.
To the Knutson motion. To adopt the staff recommendations to rank catalytic converter crime 3 to 10 converters at severity level 2, catalytic converter crime 11 to 70 converters at severity level 3, and catalytic converter crime over 70 converters at severity level 6. Estrada? Estrada absent. Ibrahim? Ibrahim absent. Just checking to make sure nobody's in the waiting room by that name. Knutson?
Yes.
Knutson, yes. Ladd?
No.
Ladd, no. Larkin?
Yes.
Larkin, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Schnell?
Yes.
Schnell, yes. Chair Mitchell?
Yes.
Chair Mitchell, yes. Madam Chair, there are 7 votes in favor, 1 vote opposed.
And with that, the motion is approved. Now that we've taken the vote, though, we should probably clarify that all of these motions are to preliminarily adopt the recommendation and move it forward to a public hearing.
Correct, Madam Chair. And I'm sure the minutes will reflect that, but yes, that is the vote.
Okay, awesome. Great.
All right.
All right, so the other item that has passed and so is ripe for discussion today is labor trafficking.
Yes, thank you, Madam Chair. So this is super interesting. And honestly, we probably would have, so right now, labor trafficking is an unranked offense. And staff's recommendation, as I was saying, our bias is to just kind of not rock the boat. And we probably would have just recommended keeping it unranked, except for the fact that the legislature has a specific directive. And let me pull that up. There we go. So in section 14 of the act says, it's called severity level ranking review. And it says the Sentencing Guidelines Commission shall consider assigning an offense severity level to labor trafficking under the existing labor trafficking statute that's not changing, 609-282 subdivision 2, and the enhanced penalty provisions that the act did change. It says section 6 and 7, but those actually aren't the correct section numbers. Those were the correct section numbers for the first version of this bill in the Senate, but when the Senate amended it, they added a section, but this particular provision of the act didn't catch that. So section 6 and 7 don't make sense. We're interpreting this as the intent being section 7 and 8, which do make sense. Those are the enhanced penalty provisions, and it tells you right there that it's referring to the enhanced penalty provisions. So in other words, what do they want you to do? They want you to consider ranking labor trafficking as it's been restructured by this bill. So how has it been restructured by the bill? Let me discuss that. So I'm gonna jump right into the description of unranked offenses rather than talk about what the act did. Because rather than spend a lot of time on what the act did, when we talk about unranked offenses, we talk in quite a bit of detail about what the restructured offense looks like. And that's really the question for the commission, is what does the restructured offense look like? Because that's what you have to rank. So we don't have to guess why some offenses are designated as unranked offenses because the guidelines tell us that in comment 2A04. Typically, an unranked offense has one or more of the following characteristics. One, the offense is rarely prosecuted. Two, the offense covers a wide range of underlying conduct. So it's really hard to call something severity level X when it can be committed in so many different ways that it might be that severe or it might be more severe or less severe, depending on how the person commits it. Or the offense is new and the commission just wants to give it some time and see how it plays out. If an offense isn't ranked, then the court has to rank it on a case-by-case basis. So, and I will say something that I found interesting that I really have never thought of in terms of one of the purposes of the sentencing guidelines. But in the discussion in the Senate hearing where this provision was adopted to say, hey, why don't we tell the Sentencing Guidelines Commission that they have to consider ranking the offense? Senator Lance mentioned that these particular cases can be very resource intensive for the prosecuting office, and the prosecutors were interested in having a ranking so they could make a decision about whether it was worth it, to invest all these resources in this offense when you have no idea what the judge is going to rank it at. The judge could rank it at a 2 or a 9. Who knows what the judge is going to rank it at? So it's helpful to have some idea of how much work is worth putting into a case at the beginning, which I hadn't thought of. So, but if there is no ranking, then as I said, the judge has to make a ranking decision based on these factors. So let's look at those typical things. First, is the offense rarely prosecuted? Historically, that's been true of labor trafficking, although perhaps with some of these changes in definitions, there will be an expansion in prosecutions, but there's been very, very little prosecution of labor trafficking. In the decade or 11 years, I guess, between 2011 and 2021, there were 2 cases. One in 2017 involved coercing an adult male to work for low wages with threats to report to immigration authority. That was ranked at severity level 6. There was a stay of imposition. The other case is really a sex trafficking case. And I don't know why it wasn't prosecuted under sex trafficking, but it was ranked at severity level C on the sex offender grid and received a mitigated durational departure, but did go to prison. As I said, though, there might be more in the future. All right, the second thing is, does the offense cover a wide range of conduct? And what we suggest in the paper is that if it did cover a wide range of conduct, the statute changes probably narrowed that range of conduct somewhat. So it's more rankable now, I would argue, after the statute goes into effect starting August 1st than it has been in the past, because before it was pretty much adult victim, child victim, and that was the distinction between, and there really is a wide range of conduct that could cover there, but with the way it's been redesigned, it really does narrow it. So to understand the range of conduct, we have to talk about the criminal elements, and that's why I didn't really talk about the bill much before, because we're going to get into the weeds here on the criminal elements, and I apologize if I'm going in too deep into the weeds, but if you do want to rank it, you have to, I think, have some idea of what the offense is. So to constitute labor trafficking, I think of it kind of as a 2-part crime. There's the action and there's the point of the action. So the action is somebody's recruited, transported, transferred, harbored, enticed, provided, or obtained, or received. And that person is defined as the labor trafficking victim. And then the second element is the point of the action. So that recruiting, transporting, transferring, harboring, enticing, providing, obtaining, or receiving has to be done in furtherance of 4 points. So any one of 4 points. And if it hits any one of these 4 things, it constitutes labor trafficking, which isn't a crime unless it's unknowingly, and we'll get to the knowingly later. Those 4 things are debt bondage, forced or coerced labor or services, slavery or a similar practice, removing organs using coercion or intimidation. So debt bondage and forced or coerced labor or services are really the 2 areas where the legislature spends all their time defining things. Debt bondage happens where somebody's working to pay off a debt. It could be a real debt, it could be an alleged debt. But it's really kind of a never-ending thing, that the reasonable value of the work isn't actually being applied to the debt, or the work's length and nature aren't limited and defined. I think of the soul, or the song, I owe my soul to the company store, you know, where you're working and you're working and you're working, but you're never really getting out of debt, and that's considered debt bondage. And then there's forced or coerced labor or services, which happens when someone's work is obtained or maintained by leverage. That's not a statutory term. That's just how I think of it. There's some kind of leverage that's making somebody work. And that leverage can be one of 6 things: sexual contact, physical restraint, or some kind of harm. It could be bodily harm, psychological harm, and very specific types of economic or reputational harm that would compel a reasonable person in the worker's position to keep working to avoid the harm. So those are the first 3 kinds of leverage. The 4th kind of leverage applies to the first 3. So it's a threat, scheme, pattern, plan, action, or statement that would lead the worker to believe without the work, someone would suffer one of those 3, the first 3 kinds: sexual contact, physical restraint, or harm. So kind of a threat to do one of the first 3. So that's the 4th kind of leverage. And if you're looking at the statute, you'll see that first one is put up front, but it just seemed easier to reference the first 3 as far as explaining it to you. So this isn't the statutory order. And then the last 2 are abuse or threatened abuse of the legal process, including a civil lawsuit, criminal prosecution, or administrative action. A lot of these seem to have to do with immigration. I could see this being something, you know, hey, if you don't do this, we'll report you to immigration authorities. I think that would qualify as an administrative action. And the final one is destroying, concealing, removing, confiscating, withholding, or possessing a passport, immigration document, or government ID, whether it's real or fake. You hear stories about that a lot in labor trafficking situations where somebody's basically locks up all the passports, that kind of thing. So that's the second point of the action. And the third and fourth points are slavery and organ harvesting. There's no definition given to that. Some of those will be rarer than the first 2, debt bondage, and forced or coerced labor or services. And finally, the labor trafficking has to be done knowingly to be a crime. So that brings us back to the sentencing guidelines. So is this such a broad range of criminal activity that it's impossible to rank? It certainly is a lot, and I can see why a reasonable commission member might say this is too broad. We can't rank it. It's just too much covered there. But I think when you look at the sentencing enhancements, it does narrow it somewhat. And what I mean by that is, let's take organ harvesting. Okay, so organ harvesting is pretty severe, and it's I can see it being a lot more severe than maybe somebody who's like maybe in a coercive work environment kind of thing. But organ harvesting is going to involve removal of an organ, which is by definition great bodily harm. And that's covered by one of the sentencing enhancements. So that's what I mean by if you just look at the base offense without a sentencing enhancement, it narrows it down somewhat. So you're really never going to have an organ harvesting situation. So the base offense only applies when the victim is an adult. The victim does not die. The victim does not suffer great bodily harm. And it happens over a limited period of time. So that's what we're talking about with the base offense. And I think as narrowed in that way, it's a lot more possible to rank than it was before these statutory changes took effect. So here are the sentencing enhancements. The big one is labor trafficking resulting in death. That's 25 years or $40,000. And I will say it's labor trafficking resulting in death, specifically when second-degree murder or first-degree murder does not occur thereby. And that's going to be important later on for our ranking recommendations. The second way is labor trafficking of a minor. That's existing. I mean, it's restructured, but that's the existing enhancement, 20 years, $40,000. Third way is labor trafficking over an extended period of time. That's new. Also 20 years, $40,000. And the fourth way is labor trafficking resulting in great bodily harm. 20 years or $40,000 also. So 15 years, $30,000. The base offense not changed. But it is changed because it has these other enhanceables that weren't there, and some of the definitions have changed as well. So the first and fourth of these are kind of the easy ones to start with because they're very familiar concepts in criminal law. An offense resulting in death, an offense resulting in great bodily harm. So we talk about these offenses resulting in death. We give you a list of them. They go from severity level 11 to severity level 8. We see a lot in severity level 8. And then there's these manslaughters involve hunting accident, spring gun, or vicious animal. Those are severity level 5. As I said, murder in the second degree is listed, but the statute specifically says if murder in the second degree isn't committed. Table 2 shows you representative offenses resulting in great bodily harm. These not necessarily every offense that results in great bodily harm or death is shown on these tables, but I think these are pretty representative offenses. And that ranges from severity level 9 down to even as low as severity level 3, with severity level 8 maybe being the most common. The second sentencing enhancement doesn't have as many precedents. That has to do with adult victim versus a minor victim. Now, there are plenty of offenses, like say sex offenses, that have multiple tiers of ages, but just having an offense be a crime if it's committed against an adult, and a more serious crime if it's committed against a child, surprisingly not that many precedents for that. Kidnapping, if a victim is under 16, increases from severity level 6 to severity level 8. And sex trafficking, if the victim is a minor, is also ranked one severity level higher, effective August 1st, because the commission just ranked it this way. So it's either severity level B or severity level C if committed by an adult, severity level A or severity level B, not committed by an adult, committed against an adult. Severity level A or severity level B if committed against a child. There's also a modifier for the crime committed for the benefit of a gang, which has an additional 12 months if the victim is under 18. The third sentencing enhancement, that the labor trafficking occurred over an extended period of time, sounds very much like a sentencing enhancement for multiple acts committed over an extended period of time in the criminal sexual conduct offenses, where a significant relative commits a sex abuse act on a child. If that's done and it's done over an extended period of time, multiple acts over an extended period of time, it's more serious than if it's just done, I suppose, once or fewer than multiple acts committed over an extended period of time. So it elevates it from a severity level D to a severity level B, or severity level D to a severity level C, or severity level F to severity level E. So it elevates it by 1 or 2 severity levels, depending on the circumstances of the offense. There's also extended period of time language in neglect of vulnerable adults, which we talked about a few months ago. The gross misdemeanor offense appears to be enhanced to a felony when that element is present, although the way the offense is worded is a little bit confusing. So that's why the commission has recommended that the legislature clear up that offense. But that's also in there. It apparently seems to be intending to elevate it from a gross misdemeanor to a felony. So so those are the enhancements. So then we get to our recommendations. So we're recommending ranking labor trafficking resulting in death at severity level 9. That's one severity level below second degree murder, felony murder under Minnesota statute 609.19 subdivision 2.1. So to get a little bit in the weeds here on why we're recommending one severity level below felony murder. So felony murder is is where you're guilty of murder if somebody dies during the commission of a felony offense, even if that death was not intended. So if somebody dies in the course of a labor trafficking, you'd think the person would be guilty of felony murder without this enhancement. But there's an element that's not written in the statute, but the courts have found that the felony, the underlying felony that you were committing during the course of the felony murder has to involve a special danger to human life, both the elements of the crime and as it was committed. So armed robbery, for example, has been found to be a crime that involves a special danger to human life. So if somebody dies in the course of an armed robbery, even if the robber never intended for anybody to die, that's a sufficient predicate for that person to be guilty of felony murder nevertheless. And that's, as I said, severity level 10. So the way I think of it is, if the legislature is saying that this offense is only committed when felony murder does not result, which is a severity level 10 offense, then what it's saying is that this enhancement only applies when somebody dies in the course of labor trafficking, but the labor trafficking was not committed in a manner involving a special danger to human life. Because if it were committed in a manner involving a special danger to human life, it would be a severity level 10 felony murder. So that distinction is what brings it down to severity level 9 in my mind. The great bodily harm, staff's recommending ranking at a severity level 8. It fits pretty well with the other severity level 8 great bodily harm offenses if you look at table 10. The recommendation is to rank labor trafficking of a minor victim at severity level 8 also. It's an offense that involves exploitation and coercion, essentially. And if the victim is an adult, it's exploitative and coercive. But if the victim is a minor, it's even more exploitative and coercive, quite a bit more, I would assume. So a presumptive commit, even at a first offense, seems appropriate in staff's mind, and it's consistent with the high statutory maximum penalty for that offense. Now, we are recommending a different severity level for offenses committed over an extended period of time. We're recommending severity level 7. So here's severity level 8 on the grid. You see that all offenses at severity level 8 are presumptive commit. Severity level 7, they are not presumptive commits unless the criminal history score is 3 or more. And then it's 54 months, as you can see here. The reason for that recommendation is it just recognizes the reality that many forms of labor trafficking are automatically going to occur over an extended period of time. I can't think of a situation where you could have the debt bondage situation, for example, that wouldn't occur over an extended period of time. It seems like it's almost an element of the offense where you have to have a debt and you're working off the debt, presumably over an extended period of time, but the money's not really going to pay the debt. So it seems impossible for that to happen over a limited period of time. So staff just questions whether that element alone should be a sufficient cause for a first offender to go to prison for basically any debt bondage situation. Having said that, we have to note that if there are multiple victims is not one of the enhancements. But if there are multiple victims, say 3 or more victims, under the sentencing guidelines, even if it's the same course of conduct, if you have multiple victims, you get to count 2 of the victims in the criminal history score for purposes of sentencing the third person. So because if you were to rank this as a severity level 7, then the first 2 victims would be worth 1.5 points in criminal history score. So that third victim would be at criminal history score 3, which would be 54 months commit. So so back to our debt bondage hypothetical, assuming it happened over an extended period of time and assuming you had 3 victims, under the sentencing guidelines, that third victim would be getting a presumptive, the crime against the third victim would be resulting in a presumptive commit for 54 months. So and by the way, the same is going to be true of severity level 6, which we're going to be talking about in a second. That third victim would be presumptive commit for 39 months. So that brings us to the base offense, which we are recommending ranking at severity level 6. it's kind of a stair step down that way, and it seems appropriate that, it's a serious ranking. It's the same, for example, as second degree assault with a dangerous weapon. But it also leaves room for more severe ways of committing the offense. So staff considered severity level 6 to be appropriate. Now, having said that, you could take the other offense and rank that at severity level 7, the extended period of time, and then take this offense and rank it at severity level, rank the severity level 7 recommendation at severity level 8. Rank this at severity level 7, and that would also leave room for more severe ways of committing it. But that is staff's recommendation. The final recommendation has to do with the severe violent offense list. So when the commission created the severe violent offense list, it put labor trafficking on the severe violent offense list. And staff's recommending keeping that recommendation kind of in a don't rock the boat mindset. But a reasonable commission members may consider removing the base offense and possibly removing when it's committed over an extended period of time from the severe violent offense list, because those ways of committing the crime don't necessarily involve the use of force or injury or the threatened use of force, which typically is required for inclusion on the severe violent offense list. But that's not staff's recommendation. Staff's recommending just keeping things as they are with respect to the severe violent offense list. So in summary, and I didn't talk about keeping it on section 6, the offenses eligible for permissive consecutive sentences, but clearly these are crimes against persons. So in summary, we're recommending labor trafficking resulting in death ranked at severity level 9, labor trafficking a minor ranked at severity level 8, labor trafficking over an extended period of time ranked at severity level 7, labor trafficking resulting in great bodily harm ranked at severity level 8, and the base offense ranked at severity level 6, and maintaining the existing language in section 6 and 8.
I meant to comment earlier that if you ever want a job as a criminal law professor, you would qualify immensely. Really nice job walking us through these offenses and helping us understand the elements and the differences and at least the rationale for the staff recommendation. I really appreciate that. All right, so open it up for questions and comments. I see Commissioner Middlebrook and then Ladd and Morath.
Thank you, Madam Chair. I have to say, I think that the rankings by staff, their recommended rankings are really appropriate given how much they've gone into and explained everything. The only issue that I would like to point out is on the severe violent offense list. I don't think that the base offense fits into that category, primarily because at a level 6 or even 7, severity level 7, those aren't what we've included historically on that list. So I would just take that one comment that's different than the staff recommendations.
Okay. Commissioner Ladd?
Thank you. I do appreciate the work that the staff did on this as well. I think one of the issues that I have that I think is inconsistent is the labor trafficking resulting in great bodily harm. On a first degree assault, when someone gets assaulted and great bodily harm is inflicted, that's a severity level 9 offense. And the missing element there is obviously in the context of someone who is subject to labor trafficking. And I sort of see that as a person or a category of persons that are more particularly vulnerable than just an assault that occurs randomly between two people without any of those other things. And so I struggle with the great bodily harm being at an 8, and I get that kind of puts the other sort of rankings sort of, I get that might upset that domino effect, but I struggle with that because I think essentially what happens then is that as a prosecutor, if you're looking at that, I don't think that ever gets charged out. And I think the more appropriate charge would be the first degree assault because it's one less element you have to prove and it's ranked at a severity level 9. And again, I think that's concerning to me because the victim in this case is in a vulnerable situation when great bodily harm is inflicted upon them, which is different than the first degree assault. And so I do struggle with that one.
Okay, that's an interesting point, yeah. Commissioner Morath?
Yeah, I guess I mirror what Commissioner Middlebrook had already said. I generally agree with the rankings that were recommended, but I'm a little bit conflicted on the severe violent offense list as well, for the same reason as the fact that the violence isn't inherent in that base offense, and especially just coming out of the sex trafficking review and the way we approach that, I just feel like this is deviating a bit from, or would deviate from the approach we took with that.
All right, other comments or questions? Commissioner Larkin.
Thank you, Madam Chair. I have a question for Professor Frakes. We're talking about labor trafficking, right?
Labor trafficking, correct.
Okay, because I'm looking at the severe violent offense list right now, and it lists labor trafficking. So we already have it on there. So the proposal would be to take it off.
So, Madam Chair, so
Go ahead.
staff's recommendation is to keep labor trafficking on there for precisely the reason you're saying, because it's on there now and it's kind of a status quo recommendation. I honestly, if we were looking at this as a matter of first impression, it might be a different recommendation. But I think the fact that it's a status, I mean, I think it probably wouldn't have the severity level 6 and 7 offenses on there, but I sort of see the tie going to the status quo in this case. So that's why we're not recommending any changes to Section 8.
Commissioner Larkin? Do you have a
I guess I
follow-up?
agree with that approach because to me, it seems like we already have it on the list and it used to be an unranked offense. And I'm just talking through my reasoning. If I'm wrong at any point, please let me know. So it's on the list. We had it unranked. The legislature said you need to rank this. So that seems to me to say they're taking it seriously. So it seems inconsistent to say, well, we're going to rank it, but we're going to reduce the penalty in terms of taking it off the severe violent offense list. So I would support staff's recommendation.
So I just want to clarify that, so staff is recommending leaving it on. What we heard Commissioner Morath and Commissioner Middlebrook suggest was only taking off the base offense, not all of the enhanced ones. So it's
That's better.
just a subset, yeah.
Okay.
And Madam Chair,
Director Wrights and then Commissioner Middlebrook.
just one point of clarification. The legislature is not requiring the commission to rank it. The legislature is requiring the commission to consider ranking it, which you're doing right now. So you're complying with the legislative requirement by having this discussion, but the outcome is not governed by the legislature.
Okay, Commissioner Middlebrook.
Thank you, Madam Chair. I just want to point out a clarification. Back when the list for the severe violent offenses was put in place, the commission did not include sex trafficking, and I think that was by mistake because I think the labor trafficking and the sex trafficking were being lumped together. And so there weren't all these different enhanced either. So none of that was even discussed or broken down at that time. And then just recently, we went through and decided on the sex trafficking that some would be on there and some would not be on there. So I think that by doing the same thing with the labor trafficking, keeping the status quo doesn't comport with sort of the history and also what we just did with the sex trafficking. I agree with Commissioner Morath on that.
Other comments? I guess the comments that I'll make are, number one, I agree with staff that the changes to the law make these offenses rankable now. I do think it was a swirly mess before. It was harder to know. There's a much bigger range of behavior, so it's easier to rank. And then the fact that it does break into multiple rankings here is evidence of the improvements they've made to the statute. So I do think we could make rankings, and I would I agree with Commissioner Rath and Middlebrook about just taking a second look at the severe violent offender designation, because with the greater specificity we have about the offenses now, I do think there's an argument to be made that the base offense doesn't need to be on that list, while the other offenses do comport more with what's on the severe violent offender list. Commissioner Knudsen.
Where's the definition of the base offense?
Well, it's,
Commissioner Rights.
so I'm using the term base offense, it's just a subdivision 2 offense. It's labor trafficking that doesn't contain one of the enhancements. So my inference is that it's labor trafficking that's committed over a limited period of time, where the victim is an adult, the victim does not die, or death is not proximately caused by the labor trafficking, and great bodily harm is not caused by the labor trafficking. So that's what I'm abbreviating as the base offense.
Thank you.
So Commissioner Ladd, if you would indulge me, I'm thinking about what you said about assault versus the great bodily harm provision. So I'm just trying to think of like how, if the case were presented to you, you would, I think I'm hearing you say that in these cases, assault in the first degree could potentially also be charged.
Yes, and it would be charged, there's less elements, right? So there's less in terms of that, in terms of a proof standard. But because the consequence carries with it, a higher level as well. I just don't know, again, why, I said it could be charged, but I don't know why you wouldn't necessarily even charge the lesser one when would be at the ranking level. And that's the struggle, because I do think that the victimology here is very different than in a typical assault that occurs where great bodily harm occurs between 2 adult people. And that's where I struggle. And I think that's an inconsistent position that the commission would take in terms of how we've ranked first degree assault. So that's what I struggle with.
But the harm to the victim is potentially even greater here because they have.
Of their
been-
circumstance.
Because of their circumstance.
Correct. Commissioner.
Oh, I'm sorry, Commissioner.
Yeah, thank you, Madam Chair. I've just got a question for Commissioner Ladd. With a first degree assault, though, the difference would be they wouldn't have to prove the intent to assault. This would just be a result from the labor trafficking.
I think there is a requisite aspect to it, though, for the labor trafficking. The labor trafficking would be an element, and there's a knowing aspect to that.
To that, but not to
Correct.
the assault itself.
Because it's a proximate cause of the labor trafficking condition. Is that what you're saying?
The knowingly goes to the labor trafficking.
Yes. Yep.
Yeah.
I see where you're saying in assault, the intent is assault.
To
Here, the
assault.
intent is trafficking and it results in harm, in this great bodily harm. Whereas in the assault, the intent is to commit the assault, resulting in great bodily harm. Okay, I see the difference here. Calling out there. Did you want to respond to that? I'm sorry.
No.
Director Wrights, did you want to respond?
I just pointed out table 2 again, it's up there, so it does show you the great bodily harm offenses. And I guess what I was thinking when making the recommendations was it's kind of more like these other things where you're doing something really bad and great bodily harm results from it, but it's not. Now, you could put kidnapping in that same boat. Kidnapping is also you're doing something really bad and great bodily harm results, but there the commission ranked kidnapping at severity level 9. But maybe that's because kidnapping is already pretty severely ranked. This would be, I think, more, you could view it either way, I think, but you could view it as doing something really bad, like depriving a vulnerable adult, maliciously punishing a child, distributing drugs, and great bodily harm results. That's a severity level of 8. And the other thing is it's kind of the stair step down from the starting point in my mind, which was murder in the second degree, felony murder, which is very little 10, so.
And Madam Chair,
Commissioner
and I
Scott?
recognize that if the ranking for the labor trafficking resulting in great bodily harm was ranked at a higher level, for example, a 9, that's the same level as the labor trafficking resulting in death, and I get sort of that inconsistent application as well. I note that, and I agree that there's some similarities with the great bodily harm of the criminal abuse of a vulnerable adult. Again, because of their circumstance, I get that there's some of that, but I felt like the ranking here seems low, but it's difficult in sort of how the rest of them get ranked, and I understand that, and I just wanted my comments to be on record about that.
That makes a lot, I mean, it makes a lot of sense. I totally hear where you're coming from. Okay, so what is the commission feeling? Is this something that people want to marinate on? Is this something that anyone is prepared to bring a motion for? I guess number one is, does the commission feel like, the first question, just nod of heads, does the commission feel like the changes to the law put this in a place where we could rank it this year? Is that, okay, so we have general agreement on that. Okay, great. All right, so we will rank it. So then the next question would be is, do you want to think about it, or does somebody have a motion that they would like to bring forward this month for consideration?
Can I ask a point of clarification?
Yes.
So are we just doing the ranking, or are we also addressing the issue about the severe violent offense list?
I think we'd want to do all of it at once.
Okay,
You know, they can be separate motions. It doesn't
understood.
all-
I just didn't know
Yeah.
if there was an expectation to, I know that the staff recommendation was to leave it alone, but based on a couple of comments by the commissioners to other commissioners to sort of parse out those, I don't want to say enhancements, but I don't know if that's the right word or not, those offenses that have other components to it versus, I'll use Nate's term, the base offense. If we were going to address that too, or we were just going to leave that alone, I just wanted clarification.
Yeah, I think that depends on the commission's will. We should clarify it either way, I think, actually. Since we're doing new rankings and it's going to be new stuff, we should, if we're not going to change that, we should say it. If we are going to change it, I think we should say it. Either way. Commissioner Shell.
I would just say that, it makes a ton of sense that we are consistent with what, that the separation that we had done before in terms of inclusion, what's included and what's not. And so, I would say that, including that highest level offense under labor trafficking in and then not having the others in would make some sense and would seem like it would be consistent with the previous action, if I'm right, if that's accurate.
All right, then I saw Commissioner Middlebrook and Commissioner Moore raise their hands. So Commissioner Middlebrook. Okay, Commissioner Moore, I saw your hand.
I'm troubled by the point that Commissioner Ladd makes, frankly. I think she's right on the great bodily harm thing, but I also understand what Director Wrights is saying about the labor trafficking resulting in death and the provisions of the legislation there. And it's a conundrum for me. I think I personally would like to think about this some more, but I mean, if the rest of the commission is ready to go forward, I don't know how we reconcile these. I could absolutely support the great bodily harm being ranked at severity level 9 for the reason that's mentioned. I do think there's something there that we need to be thinking about.
Can I ask a clarifying question?
Yes.
So if you did go that route, if great bodily harm was ranked at 9, then would you also be thinking that the labor trafficking resulting in death should be at 9, or that should be higher?
That's the
part you're not
That's
sure
the
about.
part I'm troubled with, because I recognize the point being made about State versus Anderson and the special danger to human life components. And I'm trying to envision a world or a case where you would have a charge of labor trafficking resulting in death that would not also be charged as a second-degree felony murder. And it's hard to kind of envision what the scenarios might be. Maybe the prosecutors that have that more in mind here, but I don't know if we would be doing an injustice to rank that as very level 10 or not, under the rationales put forward. So it's that issue that I'm struggling with.
Yeah, okay. No, that makes sense. And I mean, and we can think about it. I will just say that, I was gonna say this at the end of the meeting, but I will say it now too. In June, we start at 1. It is scheduled to end at 5, but we will go until we're done. So be ready to camp here, because we have a lot. We just have a lot on the agenda. So we have no choice but to get everything done in June. That's the way those are the shoes the legislature has put us in. So we definitely can bring it back if that's the will of the commission. Otherwise, if anyone feels strongly that they want to deal with this today, we can do that too. Oh, Commissioner Larkin.
Sorry.
I can't.
Just in terms of scheduling, I know it's difficult, but I mean, is there any room for us to have a second meeting, instead of one long marathon to do 2, like back-to-back days? If in fact, I mean, I'm getting the sense, and I've never ranked anything before. This is the first time I feel like, well, that's not true. This is the first time I'm being told we have a lot to rank, and it sounds like it's more than we've ever had to rank at one time or high up there. Is there any possibility of doing a second meeting in June instead of having to decide all of these things on one day? It seems like a lot to tackle.
I'm going to turn that over to Nate, because he knows the time. Like, our next thing is the meeting rules, and that's what we're butting up against. So
Okay,
he would have to give us advice on what those possibilities are.
thank you.
Thank you, Madam Chair, Judge Larkin. Yeah, it's, I guess to the question of whether we've ever had to do this,
Yes.
There's certainly a lot to do in 2021 where there were a lot of changes to criminal sexual conduct. Certainly a lot to do in 2016 when there were changes to the Drug Reform Act. But this is going to be a lot of different kinds of changes to a lot of different things. I don't know that any of them are going to be as complex as labor trafficking. Any one of the individual decision points is going to be as complex as labor trafficking, but there's just going to be a lot of them. In direct answer to your question, I don't think we can meet later than our June meeting. Maybe we could meet the next day, but we have to get our notice to the publisher of the State Register by, is it Tuesday? The following Tuesday at noon is our deadline. So we I guess maybe could meet on Friday, but that would be the last day we could meet. And I don't know, the other issue is the quorum, and people have calendars that may have filled up by then. So that there is that risk. We hope that everybody's calendar is cleared for Thursday afternoon in June. As far as the legislative calendar, not to jump the gun on the legislative update, it's foreseeable that the legislature could be voting on a public safety bill next week. And if that were the case, we could start working on things even before the governor's taken action. So we might be able to squeeze in a meeting before or after that, but not too much after.
Commissioner Ladd.
So what you're saying is that we could do if the timing of everything, we could do like a Thursday, Friday meeting. I guess the other question I would have is, again, recognizing everyone's schedules, is there any reason why we wouldn't just do an all-day marathon starting earlier on that Thursday instead of starting at our normal time? And would that give us enough time to sort of tackle what's in front of us?
Yeah, I would say, we could certainly talk about that. I think what my guess is what Commissioner Ladd is looking for is like the break to be able to process. Commissioner Larkin, I'm sorry, yes, is sort of the break to be able to process what we've learned. And I totally get that. Like, I think that would be ideal because we have had years where we've at least been able to preview all the stuff in May and then vote on it in
Sure.
June.
Yeah.
And we haven't, it's just not happening this year
Yep.
because of how they're working. So like probably, you can tell me if I'm wrong, Judge Larkin, but probably like a Thursday afternoon, Friday afternoon would like give that space for like thinking through these difficult types of issues so that we can come back and be like, okay, let's do that. I don't know. Oh. You're muted.
They automatically go to mute. The
Okay,
other
yeah.
thing I'm thinking is, what if, we have new people and that's their first meeting? And we've got this
Yeah.
pile of work crammed into, 2.5 hours and you've got to stay late. I mean, we're in an untenable position. I mean, I guess, is there a show of hands? Could people meet again on Friday afternoon? Could people meet all day Thursday? I know everyone's schedule is packed. And I have the luxury of being able to make myself available if that's an option. I'm worried about having new members and having this tremendous amount of important decision-making, and not having enough time to do it. So just for the record, I'm willing to do an extra meeting if that's possible.
Yeah, what's the will of the commission? Because I mean, I'm totally open to that as well. Commissioner Moore.
Madam Chair, the court has an oral argument on the morning of June 8th and a conference after that. There's only one case, but that would make it difficult for me to be involved for an all-day thing. Maybe later in the morning, hypothetically. And then on Friday afternoon, the investiture for the federal judge Blackwell is occurring in downtown Minneapolis, and I know a number of people are going to be attending. That's on the calendar. It doesn't mean that can't be altered, but that's just a factor to consider. Kind of an important moment.
So you get them to change his investiture.
Yeah.
Yeah.
Article 3 judges, I think.
That's in the afternoon?
Yeah.
Yeah, I was just gonna say the other option would be like morning,
Friday
Friday morning
What about Wednesday?
or Wednesday.
Yeah, Friday morning, I would be available of June 9th.
I mean, what we could do, if there is like a collective additional time that would work for this group, we could try to do as much as we can on Thursday, and if we need the extra time, we use it, and if we don't, we cancel. That's one option. Commissioner Middlebrook.
Yeah, I'm open, I think, on Wednesday, if that's another option for Wednesday afternoon and Thursday afternoon. I'm supposed to be in Duluth doing a training Friday, so that
Oh, gotcha.
Kinda.
Okay, so Friday's out.
Friday's not good for me, but I'm just one.
Wednesday afternoon works for me. What about other people?
It would work for me.
It would work for me.
Commissioner Wood? Okay. Wow, do we have consensus on that? So should we move it to Wednesday with the backup time being Thursday if we need it and cancel Thursday if we don't? Could do that.
What time on Wednesday? Afternoon.
So I think we would probably plan of 1 to 5 on Wednesday.
Yeah, and we'd have to check availability of this room.
True, yeah.
We get you covered.
Don't know. Okay. The other thing,
We know a guy.
not to throw a fly in the ointment, but we were hoping to have a little social time before the meeting to recognize our longtime staff member, Ann Wall, who's been with the commission since the 80s and will be retiring in July. So we were hoping to take some time before the June meeting to recognize Ann.
Can we do that on Wednesday?
Is she available Wednesday?
I'm sure she's available Wednesday. Yeah, we can, I don't recall any issues with that. So I guess I could check, but yeah, my hope is, to have some refreshments and just have a nice time to recognize her retirement. But yeah, it looks like we're all here on Wednesday, except one person would miss it. But maybe we could have it on Thursday if we're gonna help. Except that's an optional meeting. So yeah, we would have one staff member miss it if it were Wednesday. But maybe we could do something in-house.
Okay, well, let's tentatively plan for that with the hope that the room will be available. I mean, if it's not this one, we might be able to find another room elsewhere too that would work. I'm getting the thinky eyes.
Oh no, I mean, we're told it's gonna be available, so.
Oh,
Yeah, I heard somebody said that they knew a guy.
Yeah.
We'll take care of it.
All right. Okay, so I'm also going back, this all started over labor trafficking. Not that I'm trying to force any of you into a prolonged period of labor here with the coercive threat of anything. Leverage, yeah. Am I also hearing that people want to think about this and do this next time, or does anybody want to make a motion?
Yeah, Madam Chair, I'd like to think about it. As our executive directors stated, I think this is incredibly complicated.
Yep.
How they split it all up and all the different enhancements, and how do we put this and do all of this together in light of the assault rankings, and I think we need some time to digest that. And I'm hoping that, as Nate mentioned, that the rest of the bills and the changes in the criminal law that we're gonna have to rank coming up here, none of them are even close to this complex.
I honestly haven't even given a lot of thought to what we're gonna have to change in the sentencing guidelines to accommodate the redefinition of felony from a year and a day to a year. So that might just be a lot of staff work and maybe not a lot of commission decision work, but yeah, we're gonna have to figure that out. There's gonna be, I don't know if there are gonna be implications to the Minnesota Rehabilitation and Reinvestment Act in terms of, we have charts on the back of the guidelines that say 2/3, 1/3. I don't know if that's gonna have to change or exactly what's gonna happen there. So, I mean, they're just things I haven't really thought about, but I'm not sure that they're gonna be necessarily great and weighty decisions for the commission. I think it's just gonna be a lot of work for the staff, probably. Other than that, it's just gonna be a lot of new felonies that are gonna have to be ranked or not ranked.
Oh, is there another hand up?
She's got her hand up.
Commissioner Larkin?
Thanks. I was just going to ask, as we wrap this up, if we're not going to vote on rankings, could perhaps Commissioner Ladd, just for the benefit of the group, so we walk away understanding what we need to think about, could you just succinctly state the concern regarding the ranking in light of first-degree assaults again for us all, so we know what to have in mind?
Commissioner Ladd,
Thank
sorry.
you.
Yes. Go ahead.
Well, so my struggle is that it's, the proposal is that it would be ranked at a severity level 8, and a first-degree assault is a severity level 9 ranking. And so, but again, how it's currently laid out is that if the labor trafficking results in death, that's a 9. And so I struggle with the great bodily harm and death being both 9s. And so that's the distinction for me in trying to figure that out.
Commissioner Larkin? Go ahead,
How
Commissioner
would
Larkin.
you propose to resolve that?
Well, I think they'd all have to
Does
be looked at
murder
because
go up or first-degree assault go down? So I just want to make sure I understand what you're saying. It doesn't make sense that we have the same ranking when the underlying harm is first-degree assault or approximately caused death. I agree that makes sense, but then what's the solution? That, not to commit you to it, but do you have an idea?
I don't, and I think to have to look at the whole thing, because I think while I struggle with it being an 8, because this first degree assault is a 9, I also struggle with the 9, it being a 9 with the resulting in death being a 9 as well. And so I'm sorry, I don't have that. And I want to look at it comprehensively and do some cross-checking with some other things, but that's my struggle right there. It's with those two it's the top of the tier on those two offenses.
Understood.
And I think that reconciling that, I think it does have sort of a flow, top down or bottom up, however you look at it. And so, and I'm plucking something out of the middle saying, I don't know that that fits appropriately.
Yeah, okay, Commissioner Middlebrook?
Madam Chair, just maybe something that might be helpful too on this is to look at on the table 2 with the other crimes that result in great bodily harm that are severity level 8s now, maybe comparing those would be helpful too. So I just wanted to throw that out.
Certainly.
And
Okay. Oh, Commissioner Larkin?
sure, just so I understand, and the reason we don't want to put the trafficking that results in death at a 10 is because that's second degree intentional, not premeditated, and this death is not intentional, it's just proximately caused. So, so that's the gist of it, right?
The legislature.
That's the gist of the original recommendation. So yes, those are the competing interests there.
Well, just to be clear, felony murder is unintentional. So felony murder is not somebody intending to cause death.
Oh,
So
you're
they're
right,
both
you're
the
right.
same in that way. It's just that felony murder requires, I've lost the language because I'm in the wrong document. Let's see.
Part of it, I thought part of it, Nate, was that this one said, and it's not second degree murder.
I did, right.
Right,
That's what
right.
the
Which is
statute
not-
says.
Yeah.
Which is not to say you couldn't rank it at the same level, but the way I saw it, looking at the Anderson case, because felony murder, really the difference is that that it's committed in a manner involving a special danger to human life. So let's say that the labor trafficking, we're having somebody just work in an extremely dangerous environment that did cause a special danger to human life. That would be second degree murder. But if the person died, and the death were approximately caused by the labor trafficking, which apparently it would be. But let's say that somebody died in the course of labor trafficking as a result of the labor trafficking, as a result of doing the work, but the work couldn't be described as involving a special danger to human life. It just happened that the person died as a result of the work. That would be the severity level 9-10 distinction in my mind.
It would.
That makes sense. A lot to think about. Okay, so we will think about this and we will bring it back in June. Oh, I'm sorry, Commissioner Larkin, did you have another thing?
And again, I think we're told you guys should think about ranking these, and I think it makes sense to break them out. I mean, is this, and this is just something to think about for next time, is this dilemma everyone has described, maybe is that just a situation where we say we're not ranking that particular one, or it's ranked at either 9 or 10, depending on the circumstances? Do you see what I'm saying? Is that the one form where the facts might make a difference, and so we'd want the judge to decide what the ranking should be? So I guess what I'm saying is leave that one subset unranked with the guidance that it should be either 9 or 10. And I don't know if that's something we can consider. I'm just throwing out an idea for next time.
I don't know the answer to that. It's interesting though.
Can I ask a clarifying question?
Yes, of course.
So Commissioner Larkin, are you saying that the labor trafficking that results in death would be unranked and the rest of them would be ranked? Is that
Well,
what you're
that's what
saying?
I'm wondering, with the caveat that it's either ranked at a 9 or a 10. Not that it's completely unranked, but rather it's a 9 or 10. So I don't
So
know if we've
you're
ever had
saying-
anything like that before.
So maybe something in the comments is what you're saying.
Yeah,
I don't know if that's
I'm just-
possible, but I'm just
yeah.
for
I'm
the
just
benefit
thinking
of
of
playing out the
ways.
idea.
All right. I'll noodle it, as they say.
All right. Okay, so that brings us to the end of the bills that were ready for us to consider ranking today. So let's move on to, I think you also under the legislative update wanted to talk about, oh, that, sorry, we're not even on, let's move on to the legislative update.
I know. A lot of these have to do with each other.
Yes, they do.
So, but just to recap of what we just did, so staff's intention would be pretty much to cut and paste that section on labor trafficking and put it in next month's document that has to do with ranking offenses. So now we're moving on to the document that's called 6A, and I'm working off of an edition that's dated May 10th. So if you have an edition that's dated from last week, it's not the edition that we're working off of, and you should be able to find the May 10th edition on your website. Having said that, there are only three differences between the May 10th edition and last week's edition. One is, I think it was May 3rd. One is that the May 10th edition rewords the first page, but on the chart, the main differences are, and let me display this. So on table 1, the only differences primarily are that there are some circles on the left column, green circles. And those mean that the conference committee adopted these provisions. So what conference committee am I talking about? So this bill describes, or this paper describes the Judiciary and Public Safety Omnibus Budget Bill, which was just agreed to in principle by the conference committee last night. There's still some paperwork that needs to be done, but essentially the conference committee has agreed on what the conference report should say. And it's highly likely that will be adopted by the legislature. I would say, I would describe it as highly likely that it will be adopted by the legislature this session. They considered the House and Senate versions and Senate policy, and those are abbreviated, but that really doesn't matter that much now that they've come up with adopted language. What's not included here, sports betting and cannabis are the two that are missing. It looks like the cannabis bill is continuing to move along, so that might be enacted. The cannabis bill does create some new crimes that we'd have to consider ranking if that passed. These other bills that passed, one of them is the labor trafficking bill, and one of them is the catalytic converter bill, so you know all about those. So let's move ahead to the conference committee. So these are in numerical order, not in order of importance, but I will say it's pretty important to me personally that my agency's budget has been funded for the next 2 years, or at least the conference committee report would fund it. Not only did it fund it with an inflation adjustment, and it funded it with all the four requested change items that we asked for. So that's going to be a big deal for the commission in the future. And we'll talk about the commission in the future in just a little bit also in this report. There's changes to the list of qualified domestic violence related offenses, not really something that is going to require a lot of work in June. Criminal liability for felony murder committed by an accomplice is limited now, or will be limited if this is adopted. So that's enacted. So that's a pretty big deal in terms of accomplices to felony murders. Don't know that necessarily affects the commission much. There are expansions in bias crimes to just categories of bias crimes and to whom these bias crimes apply to. That's relevant both in terms of the crimes and looking at that, not that the commission will necessarily make changes to the crimes, but the other thing that's relevant is the commission has its own sentencing enhancement that's related to bias, and that I think has been modeled after the statute, so it's likely that the commission would change its definition of bias to comport with the statutory change. This is personally one of my favorite changes. So there are 3 ways of committing kidnapping that are listed in a sentence in the statute. Unsafe release, great bodily harm, and a victim under 16, but they're not listed in separate clauses. The commission has taken those and ranked them differently. It's very unusual to rank something differently that's not in a separate numbered clause. So it's always made me uncomfortable that this is written this way. But the legislature is sort of fixing that for me by listing these out in numbered clauses. So now the commission can actually assign clause numbers to these 3 different ways of ranking. And I'm not suggesting that the commission will make any ranking changes, but it will be a lot more specific in terms of figuring out, okay, which is which of these severity levels. I'm not going to talk about labor trafficking, and in fact, this isn't part of the House, isn't part of the conference committee report because it's its own act. It's already been enacted, and it's not going to talk about that anymore. So, organized retail theft. So this one you'll see I've only circled the Senate language here because that's the version that was enacted. Most of them are pretty similar, so I just circled the whole thing. But the Senate version requires the act to be part of an ongoing criminal enterprise with 2 or more participants in repeated acts. Now, the version that was ultimately enacted, or ultimately adopted, I should say, is a little bit different from the Senate version, but it's kind of the same gist. Instead of just being shoplifting for resale or return, there has to be some kind of a retail theft enterprise that you got to be part of, and there's a definition for that. So it is more organized retail theft than the House version. There's also a burglary for shoplifting within a year of being told to leave and not return. The change there is in our impact estimate. So we got a little pushback on our prison bed estimate from House staff, and we rethought some of our assumptions. And interestingly enough, so I did not realize that there are some jurisdictions in the state that are currently prosecuting people who let's say they shoplift at a store, they get a trespass notice, they're told you can't come back in a year, and they come back anyway and shoplift. Even though it's during business hours, they didn't break any glass or anything, they just walked in through the front door and shoplifted. But that's being charged as a burglary under the theory that they did not have consent to be in that building. They, as an individual, did not have consent, even if there was general consent for the public to be in the building. Which I guess I didn't know that was even a thing, but apparently that is a thing. And so when we went back and looked at the criminal complaints and subtracted out those cases that are actually going to be gross misdemeanors under this bill, because under the bill, just doing that is 4th degree burglary. And we're assuming in the future that's how those cases are all going to be treated statewide. Shoplifting contrary to the trespass notice will be a 4th degree gross misdemeanor burglary unless you have a prior conviction on your record, in which case it would be a 3rd degree felony burglary. And that's where those 3 beds are coming from. I do feel like that's a more accurate estimate than our higher estimate that we did before. There was a case last year that defined, a while ago, there was a Court of Appeals case that said that an aperture, so if you look at invade somebody's privacy by looking at them through an aperture, that is a crime. Gross misdemeanor and has to do a felony. And there was a Court of Appeals case that said that a camera's aperture counts as an aperture. And then the Supreme Court looked at that, and that was the law for quite a while. And then the Supreme Court looked at the issue in 2022 and said, no, that's not an aperture. So the legislature basically is reverting the law to the way it was sort of interpreted by the Court of Appeals for a while. The House version also completely repealed the statute of limitations for this offense, which has been an interesting trend lately to repeal statutes of limitations for primarily sex-related offenses. But the Senate pushed back on that and extended it to 3 years after the offense was reported to law enforcement authorities. So it is indefinite, but but basically the clock starts ticking once the crime is reported to law enforcement authorities. And that's the language that got adopted. There's also a language about deep fake sexual images, but that's traveling on its own. So that's a standalone bill that's now in conference committee. So that could quite possibly be something that we'll need to rank. That's 2 felonies, one for deep fake sexual images, one for deep fake technology being used to influence an election. Then there's, I don't know if you've heard of the crime of swatting, where you call police to respond to a situation. So there's a great bodily harm level, and there's like the basic level, but there's no middle ground there. So they decided to add a middle tier there where substantial bodily harm results. Not based on any cases that we know of, just a sort of an observed gap in the law. All right, so now we get to, and I'm skipping over the ones that were not adopted. So if there's no circle, I'm just skipping over it. The amendment to MSGC membership. So this is pretty significant. We've talked about it before, but it's significant now because it's in the conference committee report. So we can kind of sort of think about it for planning purposes. So the first change is it gives the Chief Justice's appointment authority to the Chief Judge of the Court of Appeals and to the Judicial Council. I'll be specific here. So the Court of Appeals judge, the authority now is the Chief Justice. That will become, the authority will be given to the Chief Judge of the Court of Appeals. There's no effective date on this law, but the default effective date for law changes is August 1st. So at least one interpretation of this law, and we may need to ask for counsel's advice, and I'm not sure who our counsel is, because our
That's right, 'cause it's
counsel
now on
just
the
got
bench.
elevated to the bench. I don't know if he's on yet,
Yeah.
but at least one reading of this is that on August 1st, the Court of Appeals judge member must be appointed by, the full attribute of that member is a judge of the Court of Appeals appointed by the Chief Judge of the Court of Appeals. So if we don't have a member who meets that description, then we don't have a member who meets that description effective August 1st. Likewise, the district court judge member has to be a district court judge appointed by the Judicial Council upon recommendation of the Minnesota District Judges Association. So that may be a requirement that we have August 1st. I don't know. I'd like to avoid it by seeing if we can't get the District Judges Association to make a recommendation to the Judicial Council, and then the Judicial Council meet by August 1st, which I know is a lot of moving parts to do between whenever this gets enacted in August 1st. There are 2 brand new members, a new treatment provider member, somebody who provides some kind of treatment services to people who are on felony probation, I think is how it works, and an academic member, specifically somebody with expertise in this particular area. So those will be 2 new seats, so the commission membership will expand from 11 to 13. There's an expansion to the crime victim public member where that person can also be a victim's advocate instead, but that doesn't disqualify the current public member. So anybody who currently qualifies in that seat would continue to qualify. So that doesn't make me nervous. But I'll tell you what does make me nervous is requiring one public member to have been discharged from a felony sentence. And here's why it makes me nervous. So if the governor appoints 3 public members now, right? And right now there are 3 public members who the governor is presumably considering to appoint, and none of those has been discharged from a felony sentence. Then what happens on August 1st? I don't really know. The commission won't meet the statutory requirements because there isn't a public member who's been discharged from a felony sentence. So I don't know if you just take all 3 public members and throw them back in and do reapplications, or if one of you has to go out and commit a felony, or exactly, I just don't know what happens. I'm being facetious there, so I did notify the governor's office when this vote was taken to to require a public member to have been discharged from a felony sentence. Just letting the governor's office know that, because the governor's office may be influenced by that in terms of they may try to jump the gun a little bit and appoint somebody who's been discharged from a felony sentence. I did hear back from the governor's office yesterday, and they did let me know that that they weren't going to have anybody appointed by today. So we kind of figured that out. And also that, but they're trying to work on it quickly, and they are aware of this bill. So they are tracking this. I don't know whether that means that they're going to appoint somebody who's been discharged from a felony sentence. I mean, I know there are at least one or two people who have applied who meet those criteria, this criterion specifically. And then there's also a requirement for staggered terms, but we don't have to worry about that yet. It doesn't apply until, that applies to the governor who's elected in 2026. So sorry to spend that much time on that, but that could be terribly significant to us. Now, I will say that the House author of this provision, his name escapes me right now. I can't imagine why that would be, but Fraser, yeah, Representative Fraser did say that well, I don't know whether this was his whole intent in this, but he did comment how it was important to get these people in to participate in the comprehensive review. So this was kind of the idea, is at least an idea was making these changes so that this is the body that does the comprehensive review. All right, we talked about the felony 364-day gross misdemeanor felony, 365 days and more. This is going through, interesting, prosecutors petitioning for mitigated resentencing for substantial and compelling reasons. So when a judge does that, resentences because of these substantial and compelling reasons, that judge has to inform us, and we must report that to the legislature. We took California. California has something like this. It's been in place for several years, and we divided California, divided by Minnesota. Their cases turned out to be 10 cases a year. So not as many cases as you might think. All right, so this one codifies the sentencing guidelines presumptive 5-year probation camp that makes it non-waivable, and it requires the commission to conform the sentencing guidelines. So this is something we're going to have to work on, figure out how to do this. There are a couple of differences between our list and the list that got adopted. One is harassment and stalking are added to the exclusion list. So I circle both the House and the Senate because basically both of these got changed. And the Senate version permits a 4-year probation period for criminal vehicular operation resulting in substantial bodily harm, which has a 3-year statutory maximum. So, those are basically the differences. This one did get adopted, creating a new felony crime of carjacking, which is robbery where the property is taken as a motor vehicle. So there are literally no differences between carjacking as it's defined here and robbery. You could think of this more as a classification of robbery rather than a new offense. So we did not assume for our fiscal note that you would do anything different with carjacking in the first, second, and third degree than you do now with first-degree aggravated robbery, second-degree aggravated robbery, and simple robbery, because they're the same offenses, the same statutory maximums. The only difference is that the property taken is a motor vehicle. We might be wrong. You might view a robbery of a motor vehicle to be more serious than just regular robbery, not of a motor vehicle. And there would be some precedent for that in that, we just talked about theft of a motor vehicle is ranked as severity level 4, whereas that's higher than theft normally is typically ranked. So if we're wrong about that, then there might have been a prison bed impact that we should have estimated. But we didn't see any legislative signals at all that they intended for carjacking to be treated more seriously than robbery. So we assumed, just a sneak preview into June, we'll be assuming and thus recommending that carjacking equals robbery for guidelines purposes. But just something to think about, since again, as you said, we didn't have, like in 2021, we did a lot of analysis of the crim-sex changes before they actually came, but we haven't had that luxury this time. So you will be seeing this for the first time in June, but please be thinking about this.
I think Commissioner Larkin might have just raised her hand.
Thank you, Madam Chair. Actually, I raised my hand about the last issue having to do with the 5-year probation cap.
Oh,
And,
sorry, I missed that.
My question had to do with the last issue regarding codification of the 5-year probation cap. And Nate, you said it does away with the waiver. By that, do you mean it does away with the court's ability to do a departure based on substantial and compelling circumstances? So is there a waiver rule in the guidelines having to do with that cap, or are we talking about the court's ability to do an upward departure?
Madam Chair, Commissioner Larkin, I'm using waiver and departure synonymously here. So
That's what I was asking. Okay.
yes,
All
so just right now, the guidelines, well, I think it's true of all guidelines, rules, they're all waivable by substantial and compelling, or departable by substantial and compelling reasons that are articulated on the record, but that won't be true anymore. I don't, for all I know, the conforming thing that we're going to recommend is just striking that section, because I'm not sure that section will even apply anymore. It'll just be a reference to the statute, or maybe replacing that section with a statutory reference. And the 5-year cap there will be no departure from the 5-year probation cap under the law. It's just a jurisdictional maximum.
Okay, so because the proposed statutory language simply says it may be no more than 5 years. Our
Correct.
guidelines say that, plus say, unless the judge finds substantial and compelling circumstances. So
Right,
we're assuming that because that language is not in the statute, the intent is to eliminate that departure ability.
Yes.
Got it.
Well, I'd say it's not an assumption. The guidelines are structured to work within statutory maximums. So once they move that down to 5 for probation, we don't have authority to say it can be longer than 5.
I mean, in the
Agreed.
same way that a judge can't sentence somebody to a probation period of longer than 15 years for a 15-year felony,
Right.
after this change, the judge won't be able to sentence somebody longer than 5 years.
I was just
Yeah.
confused by the reference to it will no longer be waivable because to me, waiver is different than a departure. So that's my
Sure.
confusion.
No, it was, yeah, none of the language in here is intended to be precise. It's rather intended to be concise.
General.
Trying to fit a lot of law in a short table. So looking at the next provision on expungement, I have a star by there because that, to my knowledge, when I wrote this at 5 o'clock yesterday, had not been done. This is why I don't play bingo. My mother-in-law can have like 3 or 4 bingo, she's passed away, but she could have like 3 or 4 bingo cards out at one time and keep track of all of them. I apparently missed it when the conference committee adopted this provision, but I believe this has been adopted. The expungement provisions that have been adopted. So that should have been circled when I sent this out last night. The Clemency Review Commission has been adopted. I didn't really realize, and honestly, I still haven't figured it out from the language, but apparently the clemency, this statute also allows the Board of Pardons, which consists of the governor, the Chief Justice, and the Attorney General. Right now, that has to be a unanimous vote. That will change where the governor and one of the other two voting in favor of clemency or pardon that will be sufficient. So no longer has to be unanimous, but it does have to include the governor's vote. As it was explained to me, and as I said, I still haven't figured that out in the law. All right. So this one truly had not been decided as of dinner time last night. It was decided later that night, about 10 p.m. The conference committee did adopt something close to the Senate language, but not quite. So This is the supervised release board. So there will be a supervised release board that will take away the Commissioner of Corrections authority to consider supervised release or parole, which so that will be something taken off of Commissioner Schnell's plate, at least his plate alone, and given to this 5-member board. But the 5-member board will become a 7-member board when it comes to juvenile release. And juveniles will have, that is to say, people who were under age 18 at the time they committed the offense, not necessarily at the time they're being considered for release, will all have release, even if their life without the possibility of release, after 15, 20, or 30 years, I believe. So that's different from the bill. So we never did a fiscal note on that particular provision. And I believe that 20 and the 30 have to do with how many victims. So if it's multiple victims, it'd go up to 20, and if it's 3 life sentences, it would be 30. But most juveniles will still be eligible for looks at 15 years. And that was adopted. So you can circle SB 8 there if you want, or something close to it. This is the Minnesota Rehabilitation and Reinvestment Act, pretty significant. So right now, somebody who's given a sentence of a particular number of months is eligible for release at 2/3 of that, assuming that they have not misbehaved in prison. This basically creates some wiggle room there between 50% and 2/3. And that slice, that 1/6 slice, is eligible for cancellation if the prisoner cooperates with an individual rehabilitation plan. It just goes away. So that person's sentence is reduced by 17%, potentially. And a similar thing on probation, abatement of 1/3 of the supervised release term is possible if the individual participates in a supervision plan. So very, very interesting change coming. New felony here, lying on a firearms transferee permit, which is now going to be required for certain private party transfers. You may have heard about that in the news, but our slice of that is pretty small. It's just if you lie on a transferee permit application, it's now a gross misdemeanor that'll become a felony. And there was another extreme risk protection order that was also in the news recently. That's an application with intent to harass, abuse, or threaten was a gross misdemeanor enhanceable to a felony, but that did not make it in the final report. The fentanyl change did make it in. And the paraphernalia provision and residue provision made it in. So if this is enacted, a residual drug amount contained in drug paraphernalia will no longer be a 5th-degree controlled substance crime. And then the community supervision policies also made it in. So, I mean, it's possible we might be able to do this all in a long afternoon, Madam Chair. I mean, I don't know that we'll necessarily need 2 meetings. It's certainly a broad range of territory, but it might be something, if that's, pretty much the only agenda item, we might be able to do it in a 4-hour meeting, say from 1 to 5. I don't know that we necessarily need 2 meetings now that I'm kind of looking at this and thinking about it, but I'm not going to promise you that we'll be able to finish it by 5 either. So.
Yeah, better to plan for it probably. All right. So that's a preview of what's ahead next month. Next item, do you have, demographic impact statements.
Yeah, thanks, Madam Chair. So just, so the legalized cannabis bill, I mean, it's, I guess I'll just, it kind of speaks for itself. It's, yeah, I don't think I really have much to say. The demographic impact statement on mandatory minimum sentencing this is last year's version, and I just kind of want to explain what this is doing here. So you may have seen in a previous document that there was an 888 bed prison cost to one of the proposals that did not make it in the conference committee report. So it's kind of a dead letter at this point, but it was a Senate floor amendment by Senator Limmer to make 60911 mandatory minimums hard if with respect to firearms and ammunition, not with respect to other dangerous weapons. And that would have been an 888 bed cost. This fiscal note deals with, this demographic impact statement deals with a different bill, but very similar from last year, that would have had a higher cost. And that would have been 919 prison beds. Now, the difference between the 919 and the 888 was that the version that Senator Limmer introduced and that was adopted by the Senate had an exception for unwitting accomplices. We did not know the demographics of those unwitting accomplices. We made some assumptions that brought the number down, but we didn't really know the demographics. So we weren't able to do a demographic impact statement on the 888 people because we didn't know the demographics of the unwitting accomplices, but we did know the demographics of the 919 people that it started off from. So we presented that to the legislature instead and basically explained in the email, this is probably similar to the 888 demographically speaking, but we can't give you a demographic impact statement on the 888 because we don't know what that one chunk looked like that was coming out of it. So I just wanted to sort of put that on the record there as to why we were including last year's demographic impact statement in this year's materials.
Sounds good. Okay, changing the administrative rules.
Okay. All right, so first thing I wanted to bring to your attention is the meeting calendar. So this is basically what the meeting calendar is going to look like next year, absent any changes. So that is number one for your benefit, so you can plan, assuming there won't be any changes. Kind of at least pencil these dates in to your meeting calendar. This is, of course, the commission can always change its meeting calendar, but this is based on the formula that the commission has adopted in the past. Another thing I want to point out having to do with the meeting calendar has to do with the suggestion that Commissioner Knudsen made at the last month's meeting, which was to schedule everything on the first Thursday of the month. That's a standing conflict with this room, that particular time, because apparently there's I guess I don't necessarily need to get into DOC schedules, but there's an important group of DOC members who meet at this time in this room every month. So it's not available at that time, but if there are other times that Commissioner Knudsen or anybody else want us to look into, I think that is an interesting. I mean, it doesn't have to be a Thursday. It could be a different day of the week, or it could be maybe not the first Thursday, but a different Thursday. If there are other times that work for folks, please let us know, because I think that is a helpful exercise to kind of look at what if we were to just have a simplified calendar that didn't have all these convoluted formulas in it, just the X of a month. We can look into that and see if this room is available.
Commissioner Moore.
Thank you, Madam Chair. Director Wrights, is the room in Centennial where the commission, used to meet, is that available? Is that an option?
Madam Chair,
Director Wright.
Commissioner Moore, yeah, I think that's open. I mean, I think people I've heard good things about Afton, the room we're in right now, for a couple of reasons. One is it's free parking, and two is and it's kind of a no hassle way to get there. And we do reimburse you for parking, so that's not a problem. But the other thing is, for hybrid meetings, I know of no room that has this technology that focuses on the speaker. I don't know how much the DOC paid for this technology, but it senses based on where the person is in the room. It picks up the microphones. The audio is very good. Now, they do have some pretty good audio in Lady Slipper, the room you're talking about at Centennial. But they don't have these automatic cameras. So I think we'd just be giving the public, and when I say the public, we've had almost exclusive public participation remotely since we went to this hybrid meeting format. So the public seems to really like the hybrid meeting format. And by the way, we've had more public participation since we went to the hybrid meeting format. So I think the public would just have to be looking at maybe a broad view of everybody in the room for the most part. So it wouldn't quite be the same experience for the public. That would be the downside to the Lady Slipper. Now, 230 does have something akin to the robot cameraman, I call it, where I think it does pick up. 230 is the room in the Judicial Center. Assuming that would be available, we need a judicial sponsor for that. But if that were available, it does have a little bit something like that, where it picks up on the microphone that's on the table and figures out who's probably speaking based on that. But
I think this is something we could talk about offline, and it's not something we can implement until we change the rules, so it kind of doesn't matter right now. So.
But I just wanted to point that out, that this room isn't available the first Thursday of the month. So that's a short, and here's the meeting calendar. So moving on to 7B, which is a paper called Changing the Rules for Changing the Guidelines. Starts off with a recap of where we've been. Rules were made in 1985 pursuant to legislative authority to make such rules. December 2022, we talked about possibly changing the rules to streamline the meeting calendar. And April, we talked about what a calendar might look like. So this paper first talks about the administrative rulemaking process. I don't really say much about the administrative rulemaking process in this paper. You've got a checklist that talks about it. The problem is that, well, that checklist assumes that's the simplified process. It may seem complicated, but that's the simplified process. If more than 24 persons request a hearing, then we have to have a public hearing on that, which is a more complicated process. The checklist doesn't specify exactly when in the process the rule language should be developed, but it seems like that is required fairly early on, and it seems like we might be putting the cart before the horse if we dived straight into the rulemaking process, although that's a possibility. Given our inexperience and not really having a process for writing rules, I thought it might be a good idea to try to start down the road by drafting rules, or at least starting to draft rules. And I will say, as part of that process, we then turn the rules over to the revisor's office, and then the revisor's office puts them in a proper format, assuming we can do that. But I wanted to sort of walk through Chapter 3000, and those are the official administrative rules that we have in place, written in 1984 and unchanged since then, that we're required to follow for changing the sentencing guidelines. So purpose and scope, this language basically echoes the statutory authorization governing the promulgation of the sentencing guidelines, including any modifications of severity levels and criminal history scores. That's exactly what the statute says. It doesn't, one of the points that I make in the paper is it doesn't talk about what really is or isn't covered by the rules. For example, the commission has historically considered itself to be free to make changes to the commentary without going through this rulemaking process. But that's not really spelled out in here. The second section is called Notice of Hearing, which is basically talks about an email or a mailing list that we have to have, U.S. mail, people who are interested in receiving notice of proposed amendments. And then at least 30 days before the date of the hearing, Now, that's the first time we're hearing about a hearing. So there is a hearing in the next section. It doesn't really say what the triggering event for that hearing would be. It just says at least 30 days for the hearing, we have to give our notice of intention to amend the sentencing guidelines by United States mail. We don't use United States mail. Sorry about that, but we have an email list. We've basically retired our US mail list. I haven't heard anybody complain about having to use email. And by publication in the state register. And we do that publication in the state register. And that's really the thing that requires so much time, because it's 30 days before the hearing. We have to have it published. It takes time before that to publish it. And there's also expense. So that's the notice of the hearing. And then we get to the hearing, which presumably the hearing is required for all changes to the sentencing guidelines. It just doesn't quite say why you need a hearing, but I guess it's implied, since the scope is, this governs the promulgation of the sentencing guidelines, including any modifications of severity levels of criminal history scores. I take it that you have a hearing then when you're trying to change it. But it does say a hearing on proposed amendments to the sentencing guidelines, including any modifications of severity levels and criminal history scores, must proceed in a manner specified in this part. And this talks about people having to register to talk. It does require a name, address, telephone number, and the names of any individuals, associations you represent. I don't know if we necessarily need all that detail from people. Just to identify them and have some way of contacting them is probably sufficient. This talks about notice of procedures for the hearing. The chair runs the meeting. Doesn't say what happens if the chair is not available. I don't know that I've ever experienced that. Chair's always been available, but if I assume the vice chair could proceed. It doesn't necessarily, talks about opportunity for presenting statements. It doesn't necessarily say that the chair has the right to limit time or tell people to stay on the point. Sometimes people are talking about other things than the subject of the public hearing, but I have heard the chair do that. Then there's this 5-day calendar period after the public hearing ends. And the significance of that is it means the commission can't take action right away. So it can't take action at the same date of the public hearing because there's this 5-day calendar period afterwards. Then part 500, it talks about the hearing record. It doesn't really say what happens to the hearing record, but it defines all these elements of the public hearing record. And then 600, the final section, talks about amendment adoption. It says all proposed amendments to the sentencing guidelines that do not have to be submitted to the legislature are effective on the date ordered by the commission. So this is almost a mirror image of what the statute says. The statute says that amendments that do have to be submitted to the legislature are effective on August 1st after they are submitted. And all other amendments are effective according to the rules that the commission promulgates. And the rules say they're effective on the date ordered by the commission. So it's a little bit circular perhaps, but I mean, so basically the commission orders the date, it's effective. There's no default date there. So that's kind of a quick walkthrough of the rules. I do nitpick the rules a little bit here. I've got table 1, I've got a number of things that I assume are true, but the rules don't specifically say these things. And then on the second column of that, I've got questions that the rules don't really answer, like if the chair is absent from the public hearing, can anybody else convene it? And so forth. So some nitpicky things. Not that the rules necessarily have to address every one of these things, but whoever works on drafting these rules may find this list to be helpful. Just to sort of think, is this something the rules should or shouldn't address? The second problem with Chapter 3000 is these obsolete or cumbersome requirements. We kind of talked about that. Can we just get rid of the US mail list and just make an email? Do we really need the address and telephone number, or could we just have an email instead? Or, are there different ways of identifying people? It also, it has like a separate roster. Like we don't do this, okay? But we're supposed to have like, not only the roster of people who are interested in sentencing guidelines changes, but a roster of people who would like to be notified of the adoption of this particular sentencing guidelines change. It's like, I don't know, we don't do that. We just notify everybody on the list. So, and in the same vein, you know, do we even need state register publication? I mean, we're talking about eliminating it for those, you know, legislative initiatives, but do we really need it at all? And then the third sort of nitpicky thing I have there are several instances in which Chapter 3000 could better conform to plain language in rulemaking. Rules are supposed to be written in plain language, and I think we could probably do better. So then we conclude here with the next steps, Madam Chair, which is, first of all, does the commission want to work on the rules first, or does it want us to just start with the rulemaking checklist? And I would suggest that we wait on the rulemaking checklist until we've at least agreed to a first draft of the rule change. And then the second question is, how should the commission go about drafting the rule changes? I see three possibilities. One is, Madam Chair, you could appoint a rulemaking committee. That's a process that's recommended as certainly at least a possibility in some of the rulemaking materials that I've seen online. The second option is the whole commission could just work on drafting these changes during successive commission meetings. And the third option is sort of a hybrid. Well, the commission could direct staff to work on drafting the changes. So we could work on drafting the changes, and then the commission could refine those drafts at successive commission meetings. So similar to option two, but with staff maybe shouldering some of the work for the commission. And that's all I got, Madam Chair.
Commissioner
You know, if we're looking at this, I think option 3 would be the easiest in light of some of the other things that have to happen now that that's putting more burden on staff, certainly. I would just make an offer. We ended up picking up a guy who worked in the revisor's office, doing some rule work for us. And once the framing of that is done, because he was a revisor doing this work, he knows the rulemaking process. He's wonky. And it just has been is excessively helpful, and would just offer him also to staff in terms of a resource. He's just a bright, young guy who's incredible at drafting.
I was actually going to ask you if you had advice for this process, because I know the DOC does this on a regular basis.
Yeah, we're now, we're doing more, and that's why we ended up stealing this guy from some other agency, because of the amount of work that goes into it. And, you know, even the expedited process takes a long time.
Yeah, you know, when I looked at the options, I will say that like sort of having a small subcommittee for this type of work seems to make sense to me, but not given the recent changes to the commission makeup, because I don't know even if I will be here next month. So, I mean, we've not had any appointments. So I think that, I just don't think it's a good time to do any subcommittees. Maybe that's something we could move to. But I don't know that that's a viable option for a couple of months.
It's true. I mean, nobody's seat is safe right now,
No,
except maybe Justice Moore.
Commissioner Schnell.
Maybe.
And Justice Moore and Commissioner Schnell.
Committee or two, right there, we go.
Oh, there we go. I like that. Let's do that.
Is that a motion? No.
Yeah. I mean, you were very concerned about due process. Like, you can take care of that for us. I'm just kidding. Well, anyway, so I think for now, we kind of have to go with option 3. Unless anyone sees it differently. No, okay. All right. But I do think that there are like some, you know, I would recommend, there's some sort of key decisions that need to be made. Like, I don't think you need to write all of the rules. I think it's like come and say like, you know, we could go this way or this way in drafting rules. You know, this would have this effect, this would have this effect. We could give you those kinds of direction that would then, you know, help you figure out what to draft before you draft a
Decision
whole
points.
set of rules. Yeah. Yeah, like the whole point of like this, do we need a full public hearing for ranking? Or do we want a process that has, notice and comment and all of that stuff, but not the, 7-week public hearing process kind of thing, that sort of thing. Were you gonna say
I was
the
just
same
gonna
thing?
say, I agree that if the commission could provide some level of intent, even things like avoiding, we cannot, if there's a way to not use the state public and state register, because that itself seems a bit antiquated. I mean, I understand it's official and some of those sorts of things, but, today, internet, web pages and all these other things, email distribution lists are just so different. So I mean, I think it would be good to get clarity from the intent of the commission, and then makes it easier for somebody to frame that in writing.
Yeah.
Madam Chair, can I ask Commissioner Schnell a question that just occurred to me?
I don't know if she's
So-
gonna answer that.
Well, I mean, something that just occurred to me is sort of one stakeholder group would be people in your custody. And I'm wondering, I don't know if they have access to the state register. I don't know if they have access to email. I don't know, if there's any way to include them in this process without burdening the process more. I'm not sure if we unintentionally exclude them right now by essentially requiring email.
Probably at some degree. I think, they do a lot of research, I can tell you that, and get a lot of this information around legislatively and around this, the actions even of the commission, that from just some of the conversations we've had with them. But yeah, I think that is, and then, there are ways, I think now more and more, I think we're looking at ways that people, especially where things are recorded and accessible afterward, where people would be able to access some of these types of meetings even from the inside.
Interesting question. Okay. Anything else? Any other comments or questions on this one? All right. What about you? Do you have other questions for us?
No, I don't think so. I like I think my takeaway is kind of the kind of coming up with the decision points and somehow organizing that in such a way that I think that would be a really efficient way of kind of getting commission's input. Maybe like a series of decision points.
Yeah, and that'll help frame up, as Commissioner Shaw was saying, like what the draft would ultimately need to be down the road. Yeah, okay. All right, well then that takes care of that item. And you're just on all day today, so we're back to your executive director report.
So the big news in staff land is that we had our junior staff member, Shauna, who you saw at the commission meetings, took a job in a different agency. Speaking of poaching other agencies, apparently that's a
Thing.
a thing. It was actually the first agency she started to work for, so I think she's happy to go back there. But we miss her now, so we are in the process of hiring. We just had our openings. The posting period just closed, so we're about to look at the applicants for the position, but it's actually 2 positions. So we promoted Katie, who's been with our office for well over a year, and this has sort of in light of Ann retiring. So we're not going to be replacing Ann. We're not going to be replacing someone at Ann's senior position. Instead, we promoted Katie 1 position up, and we'll be hiring both a research analyst and a research analyst intermediate. So you can think of it as we have sort of, we had steps 1, 2, 4, and 4, and now we're going to have steps 1, 2, 3, and 4 on the research side, and 1 and 2 are the ones that we're going to be hiring. So Those are the ones that we have posted, or we just had posted, and we'll be in the hiring process soon. Now, having said that, there's also a step 5, which would be the supervisor, which is being funded in the conference committee that was just adopted last night. So that's my report. A lot going on the personnel side.
That's it? Anything else?
No, that's it. Thank you.
And then also, we talked about Ann retiring.
We talked about Ann retiring. We talked about the governor's office. I mean, so I think a lot of my report was scattered throughout the meeting.
Got it. Okay, let's go ahead and move on to public input then.
Okay, so members of the public, you should have the ability to raise your hand. If you would, if staff members would just raise their hands so I can tell that that's working. And it looks like all members of the public are on by computer, so don't need to unmute anybody. So members of the public, please, at this point, you have an opportunity to make a comment to the commission if you wish. If you wish to do so, please indicate that by raising your hand. And Madam Chair, I've seen staff members raising their hand, but no members of the public have raised their hands.
I've seen the same thing. All right, well, then that brings us to the end of our agenda for today. We will have a very full meeting next time, so get ready. Put your thinking caps on and be ready to think about all this. We will, oh yeah, and do you want to talk about Ann's retirement thing anymore, or
Well,
what the sort of?
just whatever, so let's recap. What are we
Yes.
doing next month for meetings?
Well, I think we're looking at Wednesday and Thursday.
Okay.
Scheduling them Wednesday and Thursday.
And if, my concern is if we get everything done on Wednesday,
And there wouldn't be anything on Thursday.
then there wouldn't be anything on Thursday. So we'd have to do Ann's retirement on Wednesday, but then Katie would miss the retirement. Not that Katie necessarily is going to come. She's a full-time teleworker right now, so.
Well, let's put it this way. So the idea, and we'll see logistically if we can get this to work or not. The idea was to have a retirement function for Ann starting at noon on the day of our next meeting. So the idea would be to come and recognize her and share some food and give her a proper send-off for her retirement. So the goal would be to do that right before the meeting. If it works to do it on Wednesday, then I'd say let's try to do it on Wednesday if that works for you guys. But let's figure out the logistics and then you can tell the commission what we end up working out.
Okay, sounds good.
All right. Either way, wherever it is, I'm going to be there. I will just say that right now. All right.
And I expect we'll have some, I mean, I hope that we may have some people from the past
Yeah.
come. We've had history with Ann, so it won't just be us prior to the meeting.
All right. Okay, that brings us to the end of our agenda. So unless there's any objections, this meeting is adjourned and I will see you all in June.